if I put my checking account in a trust, will I be able to access those accounts to make withdrawals and deposits? And then I'll let you give the answer.
Yeah. So the answer is it depends, which is like the quintessential answer in law school. If you,
depends.
Yeah, whenever a law professor asks you a question, like 99% of the time, the answer is it depends, which is maddening.
Sure.
But the reason it depends is it depends on the type of trust. So if you're putting your checking or savings accounts into an irrevocable trust, you're probably going to lose access to them. But the majority of people don't need an irrevocable trust. The average person needs a revocable trust.
Okay.
That just means that you can change it. It can be amended. You still have power over all the assets and control that are in the trust.
Irrevocable it's permanent. You're written in pen. And a revocable, that makes sense. See, I didn't know that. So that makes sense that, so you can go in and alter it and change it. Awesome. Can I transfer ownership of life insurance policy to a trust?
So do you want to open that up?
Yep.
So generally we update the beneficiary of a life insurance policy, not the ownership necessarily.
Okay.
So like you would still be the insured and the owner of your policy, but your primary beneficiary would be your trust.
Okay.
So when you pass away, the money, a check would be written out to your trust and it'd be deposited into your trust checking account.
Okay. And not that this is on the board for Amanda and I, but what happens when you have this stuff all pre-set up and a divorce comes in? Like, is that just a whole can of worms at that point?
Yeah, it is. It's a can of worms on both ends. So if you do your estate planning, you get married and you don't update your estate planning, it makes a mess. And if you do your estate planning, you get divorced and you don't update your estate planning, it's a mess for sure. So it's one reason why I love estate planning is because it's a lifelong relationship with multiple generations of people. So I get to be there through the life events and help guide them.
And then what about someone that is divorced? I'm just trying to figure out how to word this. If someone is divorced and they need to go get this set up, does that make sense? I'm not wording that very well. So why would someone that is divorced and maybe has life insurance and they have a kid, let's say they have a kid together, what would be the benefits of going to get this done after a divorce when you have kids?
I can remind them to take off their ex-husband from the life insurance policy.
Right. I'm sure that happens a lot.
Yeah, it does. It's wild. One instance I had just a couple months ago was there was a client, he and his wife owned a ton of property together, and their divorce decree said that he was supposed to get this one property, but her name was still on the deed. So when I researched it in that county, they were joint owners. And so that could open up a whole nother can of worms down the road for their kids to fight over that. The divorce decree should still overrule and govern what happens to that. But why do you need to go through court to hash that out? Whereas we helped him get a signature from his ex and sign it all over to him. We put it in his trust and cleaned it up. So we can help a lot with actually carrying out that divorce decree and making sure things are organized and properly titled.
So, I mean, this is all, like you just said, it's a generational thing. So this is something that gets updated. You should be actively looking at this when things change. I mean, that's a reminder to me. I'm sitting there thinking, is there anything I've got to change on what we have?
Yeah.
Because I think right after we bought our California property, we came in and set all that up. So that would be the last one that we did. But let me go back to these questions. We did what's the difference between a revocable trust and a will?
It's a really good one. So one of the most common misconceptions is I have a will, I'm good. It's not true. So if you have a will and you own $101,000 or $100,001 in the state of Utah, you still have to go through probate. So people think that having a will helps them get out of probate. And I can explain a little bit about what probate is. Sure. I don't know if we've done that yet.
Yeah, we can jump in.
But probate is the court-supervised process of transferring money from someone that's passed away to their heirs or whoever under law is supposed to get those assets.
Okay.
I like to think of it as what would happen if that wasn't the case. And I picture like old Wild West movies where there's like shootouts and fighting. And if the court wasn't involved in that, it would be really difficult to buy a property because you'd never know, like, did the person who gave this to me actually have the legal authority to sell it to me? So having the probate process helps like society just runs more smoothly, even though people hate having to go through it.
Yeah, I was going to say, it's almost like a negative thing to have to get to that point, right? But I guess it's a necessity to have that as well. But so what protects you from ever having to do that?
So really the main way to avoid probate is having a fully funded revocable trust. There are some other ways you can avoid probate, but that's the main way for most people. And a revocable trust is an entity, kind of like an LLC. It's just a separate legal entity that you create, and then you transfer ownership of your assets to that trust. And so the cool thing is you can set up somebody, and that person is called a successor trustee. That successor trustee, if you pass away, they can immediately go take over managing those assets on your behalf. Whereas if you didn't have that in place, you'd have to go through court, and a judge would have to appoint someone to have the legal authority to go manage the assets.